Good morning, good afternoon, good evening, wherever you might be. A very warm welcome to you all to this inaugural session of the APAC Tech and Telecoms webinar series. This is a session and a series that has been a couple of years in the planning. Delighted to be able to launch it today with a very topical issue on the US Justice Department's final rule on bulk sensitive personal data. I'll just give a few more seconds to allow our participants from around the globe to join. But as we wait for people, just by way of brief background, my name is Frederick Chen. I'm Office Managing Partner in the Tokyo office. And along with Tommy Liu and Sherry Gong, co-leads in APAC for Tech and Telecoms. Today, we have a panel that spans not just APAC, but the US. I think we're keen to have a live presentation from people across our international firm, and for you to see them live and to be able to ask questions. Today's topic, as some of you, as many of you will know, is potentially of critical importance. This new final rule will significantly restrict cross-border data transfers and transactions to certain countries of concern. These countries include mainland China, Hong Kong, and Macau. Our panelists today will consider the new DOJ rule in depth, including what data are affected, what transactions are prohibited and restricted, and the rules impact to companies with operations in the US and businesses in mainland China, Hong Kong, and or Macau. Now, this session will be recorded. This will be shared on demand. And additionally, we'll place this recording in our Digital Transformation Academy platform. We'll send a link to the recording and also circulate the materials afterwards. We do want these sessions to be as interactive as possible. Please do feel free to put your questions in the Q&A box at the bottom. It should appear at the bottom of your screen. We'll try to answer as many of those as possible as part of this session, but to the extent that we're unable to answer them, we will follow up by email. Equally, if you have questions that you think of later on, please do feel free to contact us separately and we will respond individually. On the slide, you can see our panel, again, spanning multiple offices. Each panelist will introduce themselves in more detail when they speak, but very briefly, Charmian is our partner in our data privacy and cybersecurity team based in Singapore. She will discuss the impact of the rule in APAC and Southeast Asia in particular. Sherry Gong and Tommy Liu, partners also in the data privacy and cybersecurity team based in Beijing, and will discuss perspectives in Greater China. And Scott Loughlin is a partner and co-lead of our data privacy and cybersecurity team. And Ajay Kuntamukkala is a partner and co-lead of our international trade and investment team. They're both based in Washington, D.C., and they will discuss the scope of this rule in depth. On to the next slide, the agenda. The main items for discussion today is the background to this new rule, and then the overview and the scope of the rule, the impact of the rule in Asia Pacific, and then another theme, another topic that we want to bring out in this webinar series is the practical implications. So what are the next steps on compliance and governance? And so to get us started, I'd like to launch a quick poll. Hopefully that will come up on your screen. We have two questions, and you can see here the first one is, to what extent do you have operations in the US? This is a single choice, yes or no. And then, do you collect personally identifiable information? Again, a single choice, yes or no. And we'll give it a few seconds for people to respond, please. Maybe that's sufficient time for people to have selected their responses. If we could see the results, please. Okay. Very good. Well, thank you very much for responding. It's clear that the audience today has quite a large number. I think the poll has come off my screen. I think it was 73%. And do you collect personally identifiable information? 83. So 93% now and 83%. So very high responses. We will address these issues in more detail shortly. But with that, I would like to hand over to my friend and partner, Ajay, to talk about the background to this important rule. Thank you.
Great. Thank you so much, Fred. I'm very happy to be here with you all. So my name is Ajay Kuntamukkala. As Fred said, I lead our global international trade and investment practice. I'm basically a national security lawyer. I practice export control, sanctions, and other national security rules, such as this one we are talking about today. And it's not a coincidence that you're going to have both Scott and I talking about this rule. Scott co-heads our global privacy and cybersecurity practice. And the reason the two of us are presenting from Washington, D.C. is because this rule really combines principles from both the national security side. This is a national security rule at the end of the day, but also covers and addresses privacy-related issues and elements. So that's why both of us are on. And as we walk through this, hopefully you get a sense that really both disciplines are important when it comes to the implementation of this rule. And so let's go to the next slide. So what I'd like to do is start with the background. What is the evolution of this rule? How did this start? This first started with an executive order that was issued by President Biden. So this is the previous administration. It was issued in early 2024, February 28th, 2024. And this was Executive Order 14117. And this executive order was issued under the authority of a statute known as IEPA, or the International Emergency Economic Powers Act. And IEPA is the basis for certain of our sanctions programs. So certain national security programs, including our sanctions programs, are under the authority of IEPA. So this is a tried and tested approach that the U.S. government has taken, where it declares essentially a national emergency under the IEPA and the president issues an executive order imposing certain national security restrictions on certain transactions. And here, this executive order related to preventing access to U.S. bulk sensitive data and government-related data by countries of concern. And the EO directed the Department of Justice to issue regulations that restrict or prohibit U.S. persons from knowingly engaging in certain transactions involving countries of concern or persons subject to the jurisdiction of countries of concern, known as covered persons, that also involve access to U.S. government-related data or bulk U.S. sensitive personal data, and finally, that involve transactions determined by a DOJ to pose an unacceptable risk to national security. The executive order also instructed CISA, which is the Cybersecurity and Infrastructure Security Agency in the United States, to develop security requirements for restricted transactions identified by DOJ. So let's go to the next slide. So once the executive order was issued and directed the DOJ to issue regulations implementing the executive order, the final rule was published in January 8th, 2025. Before the final rule was published, there was a proposed rule that was published in the fall of 2024. And then we had very quickly, soon after that, several months after that, in January 8th, we had the final rule that was published in the Federal Register. The effective date of the rule is 90 days after publication, with certain requirements, certain affirmative requirements becoming effective 270 days after publication. So April 8th is when the rule takes effect. So most of the rule, including the prohibitions, the security requirements, will go into effect on April 8th. October 6th, 2025, is when the due diligence, audit, and some of the reporting requirements will take delayed effect. And we'll get into some of the details on what these various requirements are. But just from the beginning, we want to make very clear that most of the rule goes into effect in April 8th, early April 8th, with some obligations coming into effect in October. So let's go to the next slide. In the previous slide, I should mention that the rule is being evaluated by Congress pursuant to the Congressional Review Act. So during this process, Congress has the authority, and this is authority they have exercised in the past. Whenever a new administration comes in, and there are certain acts taken by the rules that are issued by the prior administration under the Congressional Review Act, Congress has the authority to let certain rules stand or disapprove certain rules that were passed at the end of an administration. And so certainly Congress can intervene here and disapprove this particular rule. We have no indication that they're going to do so. In addition, the administration, of course, always the new administration, considering this was a Biden a rule that was issued by the Biden administration, the new Trump administration, in theory, can always withdraw the rule or can make modifications to the rule. They can issue amendments to the rule if they wanted to do that. Again, we have no indication that they are interested in somehow walking back the rule. Our sense is that the new administration will allow the rule to go into effect. Now, we may in the future get modifications to the rule. And that can happen in any administration where the government learns, as the rule is being implemented and they get feedback from industry, they may make changes to the rule going forward. So that certainly can't be ruled out. Let's go to the next slide. So let's go forward. So I think you went, so let's go back 2 slides, please. There we go. So the final rule, what does this rule do? So the final rule addresses what it calls an unusual and extraordinary threat to national security and foreign policy of the United States that is posed by continuing efforts of certain countries, called countries of concern, to access the personal data of Americans and U.S. government-related data. This is a new national security program that gives DOJ both a regulatory and civil enforcement authority. And this is highly unusual, the way this rule was issued, because the Department of Justice is a prosecutorial agency. It's an enforcement agency. It has traditionally not been a regulatory agency. There are elements of regulation that they deal with. And in the past, that's really involved, for instance, our foreign investment review process called CFIUS. The DOJ is part of that process, and they have individuals within their foreign investment review section called FIRS that have historically been part of that process to review foreign investment that's coming into the United States for national security reasons. So what DOJ has now done is task that same office called the Foreign Investment Review Section with this new rule to administer this new rule. But this is unusual because DOJ traditionally does not have broad regulatory authority. It is an enforcement agency, and also it's a criminal enforcement agency. And so this rule now gives it civil enforcement authority in addition to criminal enforcement authority. So the Justice Department really has to stand up a new unit within DOJ, within this FIRS section or the Foreign Investment Review section, to administer this new rule, to issue for clarifications, to provide guidance to industry, to potentially issue clarifications and advisory opinions, to issue licenses and authorizations under this authority. So they will have wide authority to regulate and to make regulation, and they will have civil enforcement authority as well as criminal enforcement authority. And the rule incorporates, it's a really interesting rule because what it does is it incorporates concepts from the export control and sanctions regimes and it combines that with these privacy concepts. And that includes, and cybersecurity concepts. And that includes, for instance, reporting requirements, specific and general licenses. These are terms that are used in sanctions regulations, civil penalties and enforcement authority. That is directly taken from OFAC and the Commerce Department and their civil enforcement authorities. Self-disclosures, again, concepts that they have taken and borrowed from these other agencies. So we'll get into more of the details of this, but when you look at this, if you have a trade background or an export control or sanctions background, you'll notice a lot of familiar elements in this, and that's not by coincidence. So let's go to the next slide, and I think over to Scott.
Thanks, Ajay. So, hi, everybody. Thanks so much for joining. If you go to the next slide, as Ajay mentioned, I'm Scott Loughlin. I'm a partner in the Washington, D.C. office. I co-lead the privacy and cybersecurity practice here at Hogan Lovells and lead it in the United States. And for the past several months, have been neck deep in this rule. Which we should pause on a moment for how we use the title of this rule, because it's often referred to as the bulk sensitive data transfer rule. And while that may be what is often referred to, there's hardly anything that's right in that title. You'll see, when you look at that, and as we go through this, when it refers to bulk, that seems to think that there's a lot of data. That's wrong. There's a lot. It's actually not a lot of data that would trigger. It refers to sensitive data. That's the data that is covered by this is not all that particularly sensitive. Some of it is, but most of it's not. And refers to transfer, and there actually doesn't necessarily need to be a transfer for this rule to be impacted. So there can be a lot of confusion about the application of this rule just based on the terminology that's used. And we're hoping that today we can demystify this a bit and give you the sense of how is it that you can approach this rule, how to understand it, how to know when it applies, and then importantly, to try to frame out how you can seek to comply. So 4 key things to think about as you are trying to decipher this rule. The rule effectively prohibits the knowing engagement of a prohibited or restricted transaction that will involve access to U.S. government-related data or bulk sensitive data to a country or concern or a person or company that is subject to the jurisdiction of that. So those are the key 4 things that you're going to be looking at as you break down how this rule may apply to your organization. There's a lot in each one of those things. And so that's where I'm hoping to spend the next few minutes. Let's go to the next slide. So knowing, that first item, you would have to knowingly engage in a specific transaction that's either prohibited or restricted. Well, that seems to suggest that that's actual knowledge. And actual knowledge for sure will trigger this rule. But importantly, it is not limited to only to actual knowledge. It also includes anything that you reasonably should have known that would trigger the rule. So reasonably should have known triggers a standard where you would have to undertake different types of diligence, different types of reviews, and any type of transaction to determine whether the rule is implicated. In other words, it's not sufficient to claim, I didn't know that this transaction was prohibited or restricted. Instead, the question will be, well, what should you have done to know whether the rule was impacted? And that will involve some level of your digging into each of your relationships, each of your transactions, each engagement that may involve the transfer or access of data across country lines outside of the United States. And that is going to be a key component as you're looking to comply. Okay, so let's say we're going to have a knowing that there's knowing is either an actual knowledge or should have known, but what types of transactions are in scope? If you go to the next slide. There are 2. One is going to be a set of prohibited transactions, and the other is going to be a set of restricted transactions. In some ways, the terminology here makes sense. Prohibited transactions are going to be the ones that you just can't do any longer. Those are flat out prohibited. They are unlawful going forward. That is going to be a small subset of transactions, and importantly, it's going to have a big impact on specific types of organizations, but they're primarily going to be relating to data brokerage, areas where there is the buying and the selling or licensing of specific types of data. And if you're going to engage in that type of licensing activity, that type of sale activity, to a country of concern or to an organization who's subject to a country of concern's laws, that those are no longer going to be permitted. Importantly, that's going to be a small slice of what is going to otherwise be a very large pie of transactions that are going to be included. And the rest of the pie is going to be made up of what's called restricted transactions. And restricted transactions are going to be vendor agreements, any type of service provider relationships, any type of contractor relationships. That's one. Two is any type of employment relationships, any type of employment agreements where a U.S. company is going to employ individuals who are based in a country of concern. And any type of investment agreements, any type of relationships where there is a control relationship, where there is an investment by an entity who is based in a country of concern into a U.S. company, that if any of those are true, would result in the potential access of information, then those are considered restricted. Now, what does it mean to be restricted versus prohibited? Well, restricted means that you can do these types of transactions only if specific types of cybersecurity controls are implemented and effective. So in other words, you can do these transactions, but you need to make sure that your cybersecurity controls are sufficient to prevent access of this data to a country of concern. And we'll get into in a moment how restrictive that actually is in practice, and may have many of you wondering whether it's even possible. If you go to the next slide. So we covered knowing, we covered the type of transactions. What does it mean to access covered data? It may mean, hey, I have employees in China. I may have employees in a country of concern, but that doesn't mean that those individuals are accessing this data. And that is a very fair reaction. Unfortunately, the rule does not necessarily care whether someone is actually accessing the information. When I said earlier, this is a sensitive data transfer, the transfer contemplates that there's actually the movement of data. And access in this context is the broadest version of what access could mean. It's not only the physical or logical access, but it's the mere possibility of access. So in other words, if an individual who is based in a country of concern has the possibility of accessing data in the United States through a VPN, through any type of remote connection, that technical feasibility of accessing the data will constitute actual access. And as a result, that is a very broad application that goes much deeper than perhaps you may be familiar with under EU laws, where there is more of a transfer, the actual access of data, as opposed to the potential or possibility of access. If you go to the next slide, the key question then is, like, what type of data are we talking about? And it said that it was bulk and that it was sensitive. Well, you look here and you'll see what bulk means and you'll see what sensitive is. Some of this will jump out the page and you'll say, okay, genomic data, biometric information, maybe geolocation, maybe financial data, maybe that's sensitive information. Okay, but if you look at then the right side of that column, you'll see what they mean by bulk. And those are very low thresholds for any multinational organization who is going to be subject to these rules. So if you have precise geolocation information for individuals who are using a web app, that's going to trigger for only 1,000 people. If you have that information, then that's going to be considered bulk. That type of data is going to be considered sensitive and thus subject to these rules. But importantly, I want to make sure that you draw your attention to the last one, because this is where I think many organizations are experiencing difficulty. When I refer to covered personal identifiers of over 100,000 people, what does that mean? If you go to the next slide. Covered personal identifiers refers to pick any two of these things together will be considered a covered personal identifier. And I'll say this is where many organizations who are not in the traditional business of collecting sensitive information find themselves struggling, because it's not uncommon for organizations to have, a name, for example, together with an IP address or cookie data. It's not uncommon to have some level of demographic data together with advertising ID or any type of device-oriented data. It's not uncommon to have account numbers that will be associated with individuals. And all of this information, which is really goes to the way that the internet is designed to work, to have this type of data, is now going to be considered sensitive data. And if you have it more than 100,000 people, that itself is going to be considered bulk sensitive data. To give you a very real world example, suppose that you are deploying a cookie or a tracking beacon that is provided by a publisher who is based in a country of concern. Any type of social media that's based in a country of concern. If they're deploying a cookie on a US-based company's system, that is easily going to pick up more than 100,000 people, and all of a sudden is going to be brought within the scope of these rules. Go to the next slide. Okay, fourth category is like, well, who do we care about? We're transferring, we have these restricted transactions that are going to result in access to sensitive data. Those countries of concern, I think, as Ajay mentioned, includes China, including Hong Kong and Macau, Cuba, Iran, North Korea, Russia, and Venezuela, i.e. all of the countries where there has been existing sanctions and potential adversarial relationships with the United States. And thus, those are the ones that are being targeted as, quote, these countries of concern. But it's broader than just the countries. It's broader than just the nationalities of the countries. It goes to what's called covered persons. And covered persons includes both entities and individuals. Entity being companies that are either owned by a country of concern or owned by individuals or other organizations who are subject to the laws of a country of concern, or by individuals who are resident or citizens of a country of concern. And so as a result, it goes much deeper and beyond just dealing with areas where you're thinking about nation states, and instead goes directly to individuals and companies who may be organized in other countries' laws or may be subject to the laws of those countries of concern. If you go to the next slide, you'll see that that's a broad application, and really, in my mind, and I think many organizations, as they are looking and thinking about what in the world they're going to do with this rule, can really disrupt the global data ecosystem and, frankly, all multinationals who are operating in and out of these countries together with the United States. There are a number of exempt transactions, which we don't have time to go through each one of them on this call, but there are a couple of that jump out, and I'd say maybe the one that is often thought of, and frankly, where many organizations say, like, okay, I'm not going to be having that much problem here, is number 6. Number 6 on this list refers to the administrative operations within a corporate group. So say, for example, you have a US company operating in the United States, but uses shared services for an affiliate who's based in mainland China. Is that itself going to result in the application of these rules? In other words, the transfer or potential access by those employees sitting within mainland China to be able to access the data sets that sit within the United States, is that going to be considered a potential restricted transaction? And the answer is, despite the exemption number 6, most likely the answer is yes. And that's because number 6 refers to the corporate transfers, but it's not all corporate transfers. It's only those corporate transfers that are necessary to accomplish the business inside of the country of concern. Pause for that for a moment. What does that mean? Well, the rule describes it as saying, let's say you have individuals in the United States who are traveling to mainland China and need to access a secure facility. Well, then you can transfer information relating to those individuals to be able to access that secure facility because the business is in China. But what you cannot do in the same breath is to be able to allow perhaps a customer support or a customer technical support that sits within mainland China to access the data relating to US data subjects if those data subjects have no connection to China. They're not going into the places where they need to be able to work with those individuals in China. There's no connection. So effectively, they're saying outsourcing activity that is often typical and a mainstay within multinational organizations is no longer going to be permitted except in very narrow circumstances. And if you go to the next slide, and then I'll hand it over to Ajay, is the restricted portion. Remember what I said. There's some transactions that are prohibited. We can't do them anymore. And there are some that are restricted. Those are going to be the vendor agreements, the investment agreements, the employment relationships. And those are only permitted if you have the sufficient cybersecurity controls that will, quote, prevent or be sufficient to prevent fully and effectively access to covered data. And you'd say that, sufficient to fully and effectively prevent access. That standard is a standard that is unusual in cybersecurity worlds, which, as the cybersecurity professionals on the call would know, is cybersecurity is a risk management function, and there's no guarantees in cybersecurity. You can buy unlimited amount of cybersecurity related controls and still be subject to a hack, especially when the hack may come from a nation state. And in this case, the rules doesn't care. It says if you're going to engage a vendor or you're going to engage an employee, you're going to engage in an investment relationship, well, that allows for that access to a country of concern, then you have to have sufficient cybersecurity controls to fully and effectively prevent access. What does that sound like? Well, that sounds like strict liability, right? That sounds like if you are engaged in a transaction, you are subject to a data breach, then you must not have had fully and effectively cybersecurity controls to prevent access. And as a result, the risks and penalties that Ajay will get into right now become very real indeed. Ajay, to you.
Thanks, Scott. So as Scott mentioned, the operative word here is strict liability. And so these penalties and the amounts of the penalties will be familiar to those of you who are familiar with US export control and sanctions laws. In fact, they're identical. So, and this is because, again, this set of rules was issued under the authority of AIPA. And so the DOJ decided to use the same penalties that are used for other national security programs that are issued under the authority of AIPA. And that includes our export control and economic sanctions laws. So the rules allow for both civil and criminal penalties where there's a failure to comply. And on the civil penalties side, violations are subject to a maximum civil penalty of $368,000 and change, or twice the amount of the transaction. And it's a strict liability regime. So, and what that means is that for civil penalties, and what that means is there's no requirement for intent. You don't have to intend to break the law or to violate these rules for the government to impose penalties. They just need to have a violation. And that can expose you to civil penalties. So negligence is sufficient to establish a civil penalty here. On the criminal penalty side, it's anyone who willfully commits attempts to commit or conspires to commit a violation of the rule, which can be fined up to $1 million or imprisoned for up to 20 years. Again, this tracks both the export control and sanctions penalties. So DOJ plans to develop a voluntary self-disclosure program to allow companies to self-disclose. And we, I suspect it's going to look something like what we've seen on the Commerce Department and OFAC side. We also understand that they were in the process, at least in the previous administration, under the Biden administration, they were in the process of staffing up this function, both in terms of regulating, but also in terms of enforcing, that they were going to have folks that would be devoted to both civil and criminal enforcement of these rules. So let's go to the next slide. So in addition to penalties, the rules also allow for authorizations and also getting what the rules call licenses, as well as getting guidance from the agency through advisory opinions. And when it comes to licenses, there are two kinds of licenses: specific licenses and general licenses. Again, this is the same language used on the OFAC sanctions side. And so if you're familiar with that, familiar with those rules, then you'll be familiar with the concepts here. So general licenses are authorizations that are set forth in the regulations or through other rulemaking that permit certain classes of transactions, whether it's prohibited or restricted transactions, as Scott explained. There may be general licenses that are issued for certain classes of prohibited or restricted transactions, and regulate. So general licenses are licenses that are in the rules, and as long as you meet the terms and conditions of the general license, then you can avail yourself to those authorizations. None have been issued so far in the regulations. Of course, the regulations talk about exemptions, but they don't actually include general licenses, so we're yet to see those. But there are also specific licenses, and specific licenses are authorizations that you apply for in advance. And so there would be a process that's established by DOJ where one could apply for a specific license, that is, submit an application, a letter, a form. All of that is yet to be worked out, but something would be submitted, and the author and the agency would review it and make a decision on whether to grant it or not, and issue essentially a piece of paper or a specific license that authorizes you to proceed with the transactions the company has requested. So specific license, you can think about it, is not available to everybody. It's available to the company or individual that comes and applies for the specific license. The license may be conditional on additional obligations. That's in fact what we see on the export control and sanctions side. Every license that's issued usually has a set of standard conditions that are used over and over again, and as well as certain conditions that are specific to the transaction. So you could get conditions that you may not have seen before that apply to the particular transaction that's being authorized. DOJ has said that licenses would be only issued very rarely. So that is not something that we have that the agencies on the export control side and sanction side said, right? There are licenses are routinely issued by those agencies. There are certain types of transactions that have a presumption of denial that the agencies already said for certain things it's a very high bar for us to issue a license. So here DOJ has signaled that licenses are going to be used very rarely, which is interesting. And one suspects that there really has to be a showing of, perhaps humanitarian need or wind down of transactions. So temporary need for authorization as a company winds down a particular type of business or particular type of transaction. These are the kinds of things one could envision that are more limited that could be authorized. But again, we await further guidance on that front from the agency. And then on the advisory opinion, that's the process to get written formal guidance from the agency on whether a transaction or an activity is prohibited, is restricted, is covered by the rules, some interpretive question that you can go into the agency and ask the agency to resolve. Their written signed opinions can be relied upon, but obviously they do not bind other agencies other than the Department of Justice. So advisory opinions are also a possibility. Typically, agencies will allow for informal conversation. So reaching out to the agency and having a conversation with them, that's something that's not binding, legally binding, if they give you an informal view or opinion or guidance. But we have in other contexts relied on informal guidance from the agency. So let me stop there and let's go to the next slide. So I think this is over to our colleagues in Asia.
Thank you, Ajay. Hello, everyone. I'm Sherry Gong, a partner based in Beijing office. My practice area focuses on data protection and cybersecurity. Now we will discuss the impact of this rule. As I believe, this is a brand new and different regulatory regime to all of us. As Ajay and Scott introduced, it's actually an export control measure in the data transfer regime. In short, it will have broad and significant impact on multinational companies in United States, Great China, APAC, and even globally. As Scott introduced, this rule applies to a broad range of transactions and entities. It covers like vendors, transaction, employment, data sharing, investments transactions, and for entities from US SAT or United States companies, if they have global operations that connect directly or indirectly with China, Macau, Hong Kong, could be impacted by the rule, for example, through the supply chain. And for China companies, it will particularly affect the industries. Include companies engaged in the data brokerage transactions, health science transactions, financial data transfer, and data-based industries. Be more specific, if Chinese companies, they won't have to outbound business in the United States for example, doing investment or buying real estate assets in the United States, they may caught by the rule. And for foreign invested subsidiaries, ventures, rep office in China, if they can access to US data restricted under the rule, then they may be caught. And pharmaceutical companies, financial institutions, EV companies, if they have operations both in the United States and China, they need to consider the rules impact. And also for life science companies, if they play a role like CRO or they provide clinical trial support across China and the US, they also need to consider. And if the companies, the Chinese companies, Hong Kong companies, Macau companies, if they have the operating websites or applications in the United States. As you see, many of the gaming companies, cross-border e-commerce platforms, social media companies, they already have the operations in the United States where website or applications they need to consider. Also for the cloud service providers, they also need to consider the rules. And for Chinese companies, if they offer like the IT outsourcing services or data processing services to the United States companies, they will be covered. And for like the AI area, if for the large AI model developers, if they use the US BARC data for training and learning purpose, definitely they will be covered. Even for individuals, if like the Chinese nationals, if they serving as the directors, executives, or employees of the United States companies and residing in China for long term, they should be concerned about the regulations. And from other multinational companies, because the rules also restrict indirect transfer, so they also may be impact. As a result, we will suggest the companies, if you will be impacted because the compliance period is very short, we will suggest you access your operation in the United States, review the transaction related to investment, employment, vendor, and brokerage, and identify data flows between those parties, including the type, amounts of the data. And we understand this requires significant effort to access. My US colleagues will give you more guidance how to comply these measures later. And I also mentioned that you see Scott mentioned there are several exemptions you may want to consider to use, like the internal operation exemption, ordinary incident exemption for financial service, clinical trial scenario. However, those exemptions will be interpreted narrowly. To safely apply an exemption, you must understand the rules very carefully. So I will hand over to Tommy Neal before we go to the compliance measures. Tommy, over to you.
Thank you, Sherry. I think Sherry has correctly and accurately highlighted many issues that's relevant for PRC companies or any enterprises have operations related to US business. So I'll just share some very minor thoughts here. So I'm based in Hong Kong. I'm a data privacy and cybersecurity lawyer as well. I'm also focused on other technology, telecom areas. So any companies business related to US data should carefully consider and establish a bit risk-based compliance system to navigate the new requirements, basically. This would basically include conducting data mapping on what kind of data that is captured, what business activity that may enable the bulk sensitive data be accessed and covered by countries and entities, what kind of sensitive data is relevant, whether any transaction or activity is actually covered in the new rules. Most important, I believe, is any exemption that may be available. If being captured, where there's any segregation measures that may be taken to segregate the operations. For instance, in the financial industry, as any personal financial data, more than 10,000 US persons may be covered under certain circumstances, data transfer and access, where Chinese companies providing global IT services or technology solutions, these transactions may constitute a covered transaction. This means that for both Chinese financial institutions operating in the US or US financial institutions operating in China, careful considerations and assessment shall all be carried out. I'll just stop here. I think we've talked a lot. I think I'll just pass the microphone to Charmian. Charmian, do you want to share? Thank you.
Thanks very much, Tommy. Hi, everyone. My name is Charmian Oh, and I'm a data privacy and cybersecurity partner in our Singapore office covering APAC. So Singapore and indeed the rest of APAC are not listed as countries of concern in the DOJ per se, but many of us actually remain concerned nonetheless about the broader impact of this DOJ rule. And there are two areas of impact. Firstly, on the data regulatory climate in APAC more generally, and then secondly, to multinational businesses that are based here. So firstly, on the APAC regulatory climate, I think that we are likely to see national security and a conflation with cybersecurity creep into data and data protection lawmaking and regulation going forward, particularly with regards to cross-border transfers. So we may see, for example, a resurgence of data localization rules or a heavier hand of government, for instance, requirements for registrations or approvals by government authorities, especially in certain specified sectors that process more state-sensitive data. Secondly, there will be a material impact on businesses based in APAC, including Singapore, right? So Singapore, in particular, is a huge proponent and always will be of open, trusted cross-border data flows. We are essentially a free market economy, heavily dependent on open trade and investment. In fact, the genesis of our comprehensive data protection law, the Personal Data Protection Act, was due to Singapore's free trade agreement with the US, and so therefore driven by economics and wanting to attract foreign direct investment into what was then an emerging and now bustling, infocom and tech node in the region. With that said, I do think that there are still opportunities and ways to keep cautiously optimistic. For instance, Singapore is deputy chair to the Global Cross-Border Privacy Rules, or CBPR Forum, which will soon launch a cross-border privacy certification scheme among participating economies. Currently, these include the US, Australia, Canada, Japan, South Korea, and Mexico, and with hopefully more to join in due course. Additionally, the Association of Southeast Asian Nations, or ASEAN for short, comprising 10 member states, including Singapore, has been engaging closely with the European Union to produce a joint guide on ASEAN's model contractual clauses and the EU SCCs, as well as the Ibero-American Data Protection Network on their model contractual clauses to facilitate both intra and cross-regional transfers of personal data. So with that, I'm handing it back to Scott and Ajay, who will take us through the compliance and governance strategy to respond to the DOJ rule.
Great, thank you. And we've got, I think, about 8 minutes, so I'll go very quick. Scott and I will go very quickly here towards the end. And so now you've seen what the rules are. They're very complicated. So what does one do? It can look overwhelming when you think about the fast approaching implementation date for the rules, and you think about the broad scope of the rules. So what does one do? Well, first of all, if you're an organization that already has cybersecurity, a privacy and cybersecurity program and resources, and you already have an export controls and sanctions program and resources and personnel, you can leverage your existing corporate governance or your existing regulatory programs, compliance programs, to identify the transactions at issue, and trace the flow of that data and implement policies, procedures, and so forth to comply. And on the privacy and cybersecurity side, I think where your privacy and cybersecurity personnel really have expertise here in helping to implement the rule is identifying cover data and transactions, understanding the flow of data, identifying that flow of data through the organization, leveraging the existing diligence process, leveraging the existing cybersecurity program. On the export control and sanctions side, you hopefully have people who understand the approach that the United States takes to national security, how to get licenses and authorizations, how to implement compliance programs that are geared towards national security authorities, and what national security authorities look for when it comes to compliance programs. So hopefully you have that expertise as well in the organization to leverage. So let's go to the next slide. And then we've talked very much about diligence programs. So when it comes to the general compliance obligations under the rules, we've already talked a great deal about due diligence and the generally applicable reporting of obligations in the rule related to furnishing certain reports. That takes effect on April 8th. Reporting offers to engage in prohibited transactions. This is a concept that's in the sanctions rule. So if someone comes to you and proposes a transaction that's unlawful, there's a reporting obligation for that. Well, they have adopted that reporting obligation into these rules. That takes effect in October. Reporting restricted cloud computing transaction also takes effect in October. So Scott, over to you to wrap things up.
Yeah, maybe if you can skip down 2 more slides, since we have about 5 minutes left, and I know there were some questions we want to make sure we get to. 1 more if you can. I think the key question that we're getting from many of our clients at this point is just, this seems very complicated, and the answer to that question is yes. This seems like it is robust and comprehensive, and the answer is yes. So what is it that I need to do? How can I start? How can I start to engage with this? And I think many organizations where they find themselves at this particular moment is to try to do the applicability assessment, to try to do the understanding of where is it that we have a potential restricted or prohibited transaction, and then either thinking about whether we can get rid of that transaction by removing access, or whether we have to try to go and implement the cybersecurity controls that would be needed. And I think that's really where this starts. It starts with a data mapping exercise. It starts with an internal review about your transactions and corporate setup and exposure for where your connections are between the United States and any other company or any other country of concern. I think the questions that have come in are good ones. And just to hit those rapid fire, I think somebody asked about whether this applies only to B2C, and the answer is no. It applies to B2B just as well as B2C. It applies to basically any type of relationship, regardless of whether there are traditional end users or traditional consumers involved. Similarly, I think folks that ask, like, well, to what extent is there the ability of a U.S. company to enter into a transaction with with a company that's not in a country of concern, but then that company in the country then transfers data to a country of concern? And the answer is, go back to the definition of knowing, right? In other words, did I enter into this transaction, and should I have known that when I entered into a relationship with a company in Mexico, that would have resulted in the potential access of that data to an entity who is based in a country of concern? If so, then that's a restricted transaction. In other words, it's very broad about trying to say you have to have the ability of looking through the transaction. You can't try to make things so complicated through a corporate structure or a set of agreements that would make it so that you're able to accomplish something that the rules otherwise wouldn't allow. And then I think there were other questions surrounding the financial services exception. That is also a very complicated exemption, but the answer is, think of the exemptions, including the financial services one, as applying what is called a minimum necessary standard. In other words, it's not prohibiting the ability of engaging with a traditional financial transaction that may allow for the transfer of data across borders, but you can only transfer the minimum amount of information necessary to accomplish that specific transaction. And as a result, looking at the exact data flows to understand how that data is moving and what data is necessary to accomplish the transaction versus what data is maybe a nice to have is going to be a important compliance function. But all it goes back to that main takeaway as you're thinking about this is you're going to need to look through all of your corporate relationships involving US data to understand if those transactions, those relationships are going to be considered restricted, whether they're going to be prohibited, and how is it that I can be able to continue to operate my business while at the same time managing to these very real world risks, both civil and criminal. So we finished it with 1 minute to spare. Really appreciate everybody's interaction on this call with all of the questions. If we didn't have time to get to any of your questions, please do let us know, and we're happy to follow up after. Fred, anything else you want to say?
Yes, thank you. Thank you to the panelists for the various insights and perspectives. As mentioned, I think we have had quite a lot of questions, so thank you very much to the audience for your engagement. We will follow up by email to those questions. As mentioned at the beginning, we will circulate the recording and some contact details. For those of you joining from Hong Kong, we'll also circulate an online evaluation survey so that you can get your CPD points for that. And one last one, which we'll also put in the email, is that we do have our so-called Our Thinking platform that collates and consolidates some of the recent news, insights, and articles. So please do feel free to sign up to that as well. But with that, thank you very much to all of you for your time and participation. We hope that many of you can join and continue to participate in this series. Thank you very much.